He, don't want to do it. Yeah, that's the word. Tuesdays, since I do this in person, I really sit in the, we're not this person, I have the office in person. I sit in like a little room, so you can do the remote through there. Oh, okay, okay. It's just like a long day. So I literally just got yesterday my bankruptcy grade back. Oh, nice. I was like, wow, this only took forever. Yeah. We gave this in 10 years ago. Thank you. And I checked the grade distribution because I always do that first. And I'm like, oh, what's my odds of being lowest? I was like, wow, I did good. I'm shocked. Okay. I really thought I failed it. That was the worst, like, one of y'all should have warned that test was going to be horrible. I didn't know she was going to make it that way. When I took it was so bad. It was so easy. Like, it wasn't easy, but it was so much more simplified. Was it A, B, C, D, E, F, G, H? Like, it was like more parts, but it wasn't that bad, though. Like, from what I remember, it wasn't a while ago. Like, I just followed the petition. And the mean sauce wasn't hard either. It was actually really easy, but I didn't question myself. I'm like, okay, she said it wasn't easy. But I don't know. Some of them, I think it's because like I pushed that one off because I was like, I have so much time. Let's do it at the end. And at the end, I remember sitting there and I'm like, oh my god, I have to submit this. I have like 2 days and I'm just like rushing. And I was like, oh, this is the shittiest one. Done. It was so bad. I think Oprah knows that too. She knows that. Everyone knows that. It was stressful. Oh no, everyone knows like, yes. Yeah, I'm like, oh my god, I'm 10 years behind. Because I slowly worked on some parts and I was like, no, I don't know. My best class was actually white collar, and I was real shocked about that. I was Phillips? Yeah. It wasn't bad. Council with them? Yeah, I know. He used to talk about that class, and I'm like, that sounds horrible. I mean, I'm in legislation, and like, I was like, okay, it's totally this is gonna be good. And then because she's very realizing her stuff more, and I'm like, I'm not one of those people like, well, again, this is pretty good. I don't have opinions on everything. Let me do a test. I don't want to give you one opinion. What's so funny is when Charlie has to do like, we did the fall batter, and it's so funny because one of the cases is like, a lot of the cases go down, and everyone's questions revolved around it, and he looks at everyone at the end of all that, and he's like, why do all of you have good? You kind of need to move around the country, because we were all just like, yeah, it was funny, and everyone was like, he just looked at all of us.
Would you have one? No. Tram.
I would agree.
Yeah. My professor was literally like, why does everybody have guns? I need to move out of the country. Give them a key. They're already nervous.
Did we agree?
I never know how accurate that clock is back there. Anybody know what time it is?
5:45.
So it is accurate.
Yeah.
How about
Yeah,
that?
I had 5:45.
Okay. All right. Good to know.
This is on the right time. Infinitely.
Very good.
Oh, wow.
Okay, well, welcome back, everybody. Welcome back. Whether you're here with me in person in Orlando, if you're over there in Cocoa Beach, or where else? East Orlando, or State of Confusion. I guess that's an official state, I guess, right? We've all been in the state of confusion from time to time. Oh, Miami, got someone in Miami-Dade. Hello down there in Miami-Dade. Cocoa Beach, East Orlando. Is this not East Orlando?
Central.
Hey, East Orlando, where are you? Anyway, welcome back, everybody. Appreciate you being here. Hope you had a great week. Yeah? All right. Good. And as always, I thank you for indulging me, as I love to start our classes with prayer. And as I mentioned before, I'm not praying at you. I'm praying for you. And if you wish, I'm praying with you. But of course, the with you part is totally optional. But anyone have something they want me to throw in for the prayers, a particular intention? Anyone? Anyone at home got a particular intention you want me to throw in on the prayers? All right. Well, you know what your intentions are, and so does the Lord our God. So whether you say them out loud or not, he knows. Oh, yes, Mike, what was that? Bar passage. Oh, man. Yes, that is critical. You know, and we all need to pass the bar because it's the bare minimum. You know, we think of the bar as this extraordinary event. And of course, once you pass the bar, you indeed should celebrate. What you've done is an achievement worth celebrating. But to help you put that achievement in perspective, you know, it's what makes you a lawyer. Exactly 100% of the lawyers you'll ever meet have passed a bar exam. It's not an unusual event. It's kind of like you can't be a person unless you're living and breathing. Well, you can't be a lawyer unless you've passed a bar exam. So what I'm trying to inspire in you is the spirit that this is something you can do. You can pass the bar. And I know when we look at your particular law school, and we look at bar passage rates, it looks a lot like the flip of a coin, doesn't it? Give or take 3 or 5%, it's 50%, 50-50, flip of the coin. So you got to be on the right side of that 50%. So take your studies seriously, take responsibility. Obviously, some folks are better at what they do than others. Everyone has their shortcomings. So if you happen to have taken a topic where there were some shortcomings, you've got to step up and you've got to make up for that. Maybe that's terrible to say. Maybe it'd be easier to say, you know, there should be no shortcomings, but humans are humans. So inevitably, in any course of study at any law school, there's going to be a class, maybe 2 classes, where there's a portion or maybe a small portion or a large one where there were shortcomings. So you've got to take responsibility. You've got to step up. You've got to learn that. So Lord willing, if God is willing, the creek don't rise, I won't be one of those shortcomings in your education. I certainly do my best not to be. So, and I hope that's true of everyone's class that you ever take. So Mike, yeah, I'm happy to include that. I'll make that my intention with this prayer. I'm praying for all of you who intend to pass a bar exam. All of you who are out there right now. A former student reached out to me not long ago. Carlos, I doubt you're listening because you already took the class, but reached out to me and asked me specifically for that prayer because he's studying for the bar. He's taking it really soon. So whether you're taking it sooner or later, this prayer is for you. And I pray in the name of the Father, and the Son, and the Holy Spirit. Amen. Our Father who art in heaven, hallowed be thy name. Thy kingdom come. Thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Come, Holy Spirit, be with those who are studying for the bar. Give them the wisdom they need. Help them find the time that they're looking for. Help them to be efficient and proficient in their studies. And ultimately, let them become the lawyers they want to be so that they can do your will, so that they can make this world a better place for those who need defense of their legal rights. And I ask this in the name of my Lord and Savior, Jesus Christ. Amen. In the name of Father, Son, Holy Spirit. Amen. All right, so where were we? Well, we're on our third class, so we're going to cover chapter 3. Anybody see a pattern emerging? All right, I hope so. And of course, I have some promises to keep, do I not? It's the last class in the month of January. And I boldly proclaim to you that before the month of January was out, you would know how to fire up and get into action your state government, investigating and perhaps even prosecuting your client's alleged victim of violation of the Florida Civil Rights Act. Will I keep that promise? Will you know that information before today's class is out? Let's see, right? Hold me accountable. That's all I say. Hold me accountable. But before we march forward into chapter 3, as I left chapter 2, I promised that I would begin today with any unanswered questions. Are there any questions left unanswered from our study of chapter 2? Anyone? Anyone? If you're at home, you can see, let's see, imagine this is your screen, okay? Over here on the side of your screen, you can type a question. So go ahead and do that if you have a question about chapter 2, and I'll address it in that way. But anyone here? All right. If I see a question later typed on the screen, I'll certainly address it. But for now, let's take a look at chapter 3. As I mentioned when we addressed chapter 2, the structure of the chapter I wrote in chapter 2 is a similar structure to what I wrote in chapter 3. I begin with a look at ethics, and then I move on to some procedural knowledge that you'll need to know. And why do I keep going back to ethics? Well, everyone's got their favorite topic, right? As you know, I only play professor once a week. It's not how I make my living. I am an attorney. Specifically, I'm your friendly neighborhood bar grievance defense attorney. If you're a member of the Florida bar or the DC bar and you have an ethics complaint, you have an ethics violation, you have a bar complaint, someone's after your license, I'm here to help. So that's what I do for a living, and it brings me great joy. And that's why no matter what topic I seem to be teaching, I always seem to go back to ethics. But I think that's okay because as a practicing lawyer, ethics is one topic you've got to know. It's not an excuse to say, oh, I didn't know that that was a violation of the rules regulating the bar. That's obviously not a valid excuse. It's not going to get you very far. And it's a topic that every lawyer needs to know. I don't care what specialty you wish to specialize in. You still have to know the rules regulating the bar, and you still have to follow them all. So I think it's fair game in any topic, and certainly I think it's fair game in this one. And where I bring it up here is in the beginning of chapter 3, and we talk about here lawyer ethics in constitutional litigation. And I talk about it within this chapter of pleading requirements because structurally that's a good place to address it. After all, can you bring the claim? Can you put that in the pleading? And we talk about some issues there of lawyer ethics. First, I took a look at rule regulating the Florida Bar 4-3.1. This is Florida's codification, if you will, of Model Rule 3.1. If you've taken your PR class already, you've spent most of your focus on the model rules, but hopefully they warned you that there isn't a jurisdiction that has wholeheartedly adopted those model rules without modification, and Florida is no exception. So we take a look at 4-3.1. It talks about meritorious claims and contentions. You have an obligation as a lawyer to only bring a meritorious claim. Likewise, when you're defending against the claim, you have an obligation to only bring a defense that is meritorious. The rule there reminds us that a lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis in law and fact for doing so that is not frivolous. Not frivolous. So the standard is stated in the negative. You have to avoid frivolity. You have to avoid your claim or defense sinking so low as to be frivolous. Now, what if you bring a claim or defense and ultimately you don't win? That's bad, but that's not necessarily evidence of a frivolous claim. Not necessarily. So frivolous is something deeper, something worse, something lower than just a losing claim or defense. It's one that doesn't have a good faith basis in law or in fact. So can you bring a claim that you think might not prevail? The answer is yes, so long as that claim is not frivolous. Can you assert a defense for which there is scant evidence and you might not prevail on that defense? The answer is yes, so long as that defense is not frivolous. So there's your legal standard. It's stated in the negative, not frivolous. Now, what I would point out there is a very important phrase in that rule. It says there that you can bring a good faith argument for the extension, modification, or reversal of existing law. Now, by way of best practice, I would advise you to state that you're doing so up front, by which I mean state it before someone accuses you of having brought a frivolous claim. As you might imagine, if you assert in response to an accusation of having made a frivolous claim or defense that you were seeking a good faith argument for an extension, modification, or reversal of existing law, that might be suspect. However, if you state that up front, you're better off. Likewise, what about if there is adverse law? If the law is not in your client's favor, can you still bring a claim? Likewise, on the defense side, if the law is not on the defense side, can they still bring that defense? And the answer can be yes. The answer is yes, so long as bringing that claim or defense is not frivolous. And within that definition of not frivolous is your good faith attempt to extend, modify, or reverse existing law. I believe this standard is important for the constitutional law litigator, because in many cases, what you're saying is that a law on the books, an enactment of the legislature, is there, it's enacted, it's in place, but you think it may be unconstitutional. So in other words, you're arguing against the constitutionality. In other words, you're arguing for a good faith extension, modification, or reversal of that statute. So that's just one example. But I would caution you as best practices to state that up front. Is it required that you state that up front? Is it too late to state that after you've been accused of a frivolous claim? No. You can state it afterward. But of course, it's more suspect if you state it afterward, right? Now, with that in mind, let's take a look at another ethics issue. What about statute or law or case law precedent that is adverse? Are you obliged, if that statute or case law precedent or law is adverse, to point it out to the court? And the answer can be yes. The answer is yes if your opposing counsel drops the ball and doesn't do what your opposing counsel's job was to do. It was your opposing counsel's job to point that out. But if opposing counsel fails to do so, then the ethics rules make it your job to do that. Now, again, it's not required, but as a point of best practice, I would urge you to point it out first and not await the negligence or incompetence of your opposing counsel. Why? Because you can make a more powerful argument that way. To see what I mean, imagine two examples. Example one, there's a case in the dustier end of the reporter shelf, and I'm talking old school here. Everybody finds their cases online nowadays, but imagine there used to be actual books on a bookshelf, okay? So I'm talking about an older case, harder to find perhaps. not talked about every day anymore. Imagine in example 1, you make your argument and you don't mention it. Then opposing counsel crushes you by mentioning it. Now, if you do get a chance to talk again, you're behind the 8 ball, are you not? Let me try to distinguish that. Maybe that one shouldn't apply. You look terrible from a persuasiveness standpoint. You haven't done anything unethical, but you're going to lose your case, right? Because that's not a persuasive presentation. Oh, big board went off. On the flip side, imagine this. As part of your case in chief, you make the argument, and as part of the argument, you efficiently distinguish that bad case. And then, in closing, make your best argument. Now, what's opposing counsel going to do? Just repeat what you already said? You headed them off at the pass, so to speak, right? From a persuasiveness standpoint, you've already addressed that issue. You might have to address it some more in rebuttal, but it doesn't have that crushing effect it would have if you hadn't addressed it in the first place, right? So that's another ethics issue I would talk about. And also, I give you that case law precedent to look at, Jones versus Barnes from the Supreme Court of the United States. And I love addressing this case because you can think of it as the Froggy versus Butts case. Froggy versus Butts case. Did you look at the facts? Richard Butts was robbed at knife point. Who was he robbed by? He doesn't know the name of the assailant, but he knows the nickname. It was Froggy. That's the assailant's nickname. All right? So I got a case that's Froggy versus Butts. How do I resist putting a case like that in my case book? Come on, man. You're writing this case book. You're going to find a way to get Froggy versus Butts in there, aren't you? All right. So let's take a look at Froggy versus Butts. And what's going on there? Well, there's a appeal, right? Because there's a conviction. And one thing, I don't do criminal law, but one thing I understand is if you're in jail, you'd rather be out. Makes sense to me. Maybe you can find a client who feels otherwise, but probably not, right? So as part of that appeal, this incarcerated defendant wants to throw everything in there. But the court-appointed lawyer decides to only make some of those arguments. Now, this would have been an easy case had the arguments the court-appointed lawyer left out been frivolous. If they were frivolous, he was ethically or she was ethically obliged to leave those arguments out, right? But that's the easier case. That's not Froggy versus Butts. In Froggy versus Butts, none of these arguments were frivolous, but the court-appointed lawyer left them out anyway and didn't win the case. So what's the question? What are we arguing here in front of the Supreme Court of the United States is whether the lawyer had an obligation to make those non-frivolous arguments. And the Supreme Court of the United States answers that question by saying what? No. The lawyer has the freedom. Oh, terrible pun. We're talking about a criminal law case and someone's in jail, right? The lawyer has the ability, no pun intended, but freedom. The lawyer has the freedom or ability to pick and choose the arguments. Here's how the ethics goes. Okay? When it comes to the objectives of the litigation, the ultimate decision maker is the client. When it comes to the means by which those objectives are pursued, the ultimate decision maker under the rules regulating the bar is the lawyer. Applying that rule to Froggy versus Butts, we find that the lawyer did have discretion or ability or freedom to leave out arguments, even arguments that were not frivolous. And there's some great quotes in the very narrowed down excerpt of the case that I gave you there. For example, talks about Anders versus California. And if you're a criminal law student or a criminal law lawyer, you know about the Anders brief, right? The Anders brief is what the court-appointed appellate lawyer is required to submit even after the court-appointed appellate lawyer has determined that there are no meritorious arguments to be made. Because it's a criminal law case, Anders says that the court-appointed appellate lawyer who isn't able to identify a meritorious appellate point, still has to submit this bare bones Anders brief. So do we extend or extrapolate Anders to say that that means you've got to throw in every argument? And the answer is no. In Anders, this court held that an appointed attorney must advocate his client's cause vigorously and may not withdraw from a non-frivolous appeal. The Court of Appeals majority held that since Anders bars counsel from abandoning a non-frivolous appeal, it also bars counsel from abandoning a non-frivolous issue on appeal. That is what the lower tribunal held, and that is what the Supreme Court of the United States reverses. No, says the Supreme Court of the United States. A non-frivolous argument can be abandoned. You're not obliged to let your client decide how you, the professional lawyer, will achieve your client's chosen goals. You are obliged to pursue those goals and to pursue them with your best efforts and to pursue them in good faith. But as the professional, the rules regulating the bar defer to you to decide how to pursue those goals. So that's the takeaway. How about this language that I left in the excerpt from Froggy versus Butts? Quote, there is, of course, no constitutional right to an appeal, end quote. Whoa, did you know that? The Supreme Court of the United States says there's no constitutional right to an appeal. As a board-certified attorney, I would have preferred different language. Helps keep me in business, of course. But there is no constitutional right to an appeal, according to the Supreme Court of the United States. The actual site, of course, isn't Froggy versus Butts. It's Jones versus Barnes, 463 U.S. 745, Supreme Court of the United States, 1983. So, ultimately, the court holds this, quote, this court's decision in Anders, far from giving support to the new per se rule announced by the Court of Appeals, is to the contrary. As I told you, that lower tribunal ruling is overruled by Froggy versus Butts. To continue the quote, Anders recognized that the role of the advocate requires that he support his client's appeal to the best of his ability. Here, the appointed counsel did just that. Hey, this attorney picked and chose between arguments. Quote, for judges to second-guess reasonable professional judgments and impose on appointed counsel a duty to raise every colorable claim suggested by a client would disserve the very goal of vigorous and effective advocacy that underlies Anders. End quote. So what's the Supreme Court of the United States acknowledging there? They're acknowledging that sometimes when it comes to rhetoric, when it comes to persuasion, sometimes you're better off focusing on the stronger arguments instead of throwing in all the weak arguments along with the stronger ones. We as lawyers can ethically do that. And you might argue that we as lawyers should do that because it's a matter of persuasion. Here, the court-appointed attorney abandoned arguments that were not frivolous, abandoned arguments for which there was a basis for reversal, but did so in favor of stronger arguments. This attorney was just using his or her best judgment, trying to be as persuasive as possible. And the rules regulating the bar do not, I repeat, do not prevent us from doing that. Quite to the contrary, if one of the takeaways you reached from your professional responsibility class is that you must be timid, then that was not the correct takeaway. Dispel yourself of that notion. If one of the takeaways you got from your personal responsibility class is that you can't be a diligent and aggressive lawyer, then you got the wrong message. Change your mind on that, especially when it comes to issues of a violation of your client's constitutional rights. Your client deserves nothing less than diligent, effective, and aggressive advocacy. Of course, that advocacy must be within the bounds of the rules regulating the bar, but within those bounds, you've got to fight for your client's rights. Because that's what we are. We're the solution to picking up weapons and fighting in the streets. We're the solution to having violence as the answer. Violence isn't the answer. Violence can't be the answer. Lawyers can substitute. Lawyers who are effective can go to court and in that way find a non-violent solution. But so long as we're non-violent and so long as we're not frivolous, we lawyers need not be timid. We can be aggressive advocates within those bounds. And I would encourage you to be that kind of advocate. But also encourage my computer to come back. Computer, we are experiencing technical difficulties. Please stand by. Signed out. I've been signed out. I have to verify it's me. Yes, I'm me. That didn't work. Okay. Okay. All right, I'm signed in, but I'm still dark on the big screen, huh? Okay. Present. I see nothing. All right, I apologize for the technical difficulties, but I will solve these technical difficulties, and it's not fair to you that you should have to sit around while watching me solve these technical difficulties. We always take a break somewhere in the class. I know this is a little bit early to take that break, but let's take our 10-minute break now. Then not only will you get your break, but you won't have to stand around watching me try to figure out how to get the computer to do what the computer's supposed to do. So I see on the clock in the back, if it's right, apparently it's right, it's what, 13 minutes after 6? I'll see you at 23 minutes after 6. And hopefully you'll not only see me, but you'll see something more than just blankness on the big screen over here. See you in 10. Most computer problems, turn off, turn back on. So that's what I'm gonna do.
I suppose you have a lot on your good.
I guess so. I'll find out in a minute. I just hit reset or restart.
I was just looking because sometimes the cables get undone.
Oh, no, that was the thing.
Yeah, no, they're.
I presumed it just timed out because I hadn't moved the screen over. But, you know,
But it's shiny.
yeah, there's a light up there. Didn't detect another display. That's a bad sign. Time for me to go get a professional. I'll be back.
Take your time, no rush. Oof.
Yeah, I had it here, but it went blank. I just figured it timed out and never came back. Tried everything. I am. Yeah. Want me to start the presentation? Will that help? I didn't know about the touch.
Well, it looks like it's on.
Yeah, there's clearly a light bulb shining up there, but
Okay.
a lot of good it's doing us here.
Let's try this. Maybe just, shut down.
Oh, shit, can I turn that on?
Yeah.
Okay. Shut down, restart. That's not a good restart.
Um,
Shut down. Okay. Yeah. Okay. Good luck to us.
Yeah, that's so sick of thinking. Try to. Oh.
I was just like, can you hear this on the thing?
Did you break it? I didn't break it. Did you break it?
I don't know.
It wasn't me.
You think-
It wasn't me. Who broke it? Did you break it? Did you break it? No. Did you break it? No. Who broke it? Bunch of good lawyers here. Everyone knows they have a right to remain silent. I appreciate that. It's smart.
yeah.
Yeah, if it's over there, I'll just stand over there.
Sorry about that.
I just hold up this little one. That's all. I'll hold it over my head. Is that a good idea? I'll take the little desktop monitor. I'll just hold it over my head. Probably dating myself, but there used to be a movie. John Cusack, I think it was, holding the boombox over his head outside the woman's window. Yeah, I'd be like John Cusack. You remember that movie?
Yes, sir.
Okay, you were 2 or 3 or something. Hey, yes.
So I got some projector working after, in that room.
It works over there.
Yeah, but the thing isn't pulling down, but the projector still shows.
Huh. All right, well, I'm gonna leave it up to a vote. Okay, apparently I've got a projector over there working, not over here. So I'll do a show of hands. The 2 choices are this. We can stay put. I'll be as energetic as possible, but I'll have no slides. That's option 1. Option 2, we all pick up our stuff and go next door. Shall I open the floor to debate before we have a vote? Oh, wait. So you see the slides back there?
Yeah.
I didn't know that.
Oh, okay. Well,
Okay, all right. So how many of you can see the slides back there then? 1, 2, 3. Is it just the 4 of you?
You can turn that.
Josh, can you put it under that monitor?
Yeah.
I can try. I'm not sure.
If it wasn't for COVID, I'd ask everyone to move into the back 3 rows. But of course, social distancing, so I can't make that request. Fingers crossed. If those monitors are up, then that one could be up, right? Could be. Fingers crossed.
We could have been in the other room by now.
It could have been the other room by now. Yeah, no, it's a good point. What happened?
Yeah, I'm trying to turn this TV on. Normally when I turn the computer on, it just turns on automatically. So I don't know why it's not on.
Okay, well, that solution is not going to happen. All right, so that brings us back to not 3 options, but 2 options. Option 1, stay put. I do as much singing and dancing as I can to try to keep you awake, no slides. Option 2, we all pick up our stuff and we go next door. If you'd like to vote for option 1, raise your hand. No one wants to see me do the Irish jig, huh? I'm doing my best here with the jig. All right, option 2, we all pick up our stuff and go next door. People are standing up. Okay, that's talk about voting with your feet. That is voting with your feet. All right, let's all head next door. Please remain socially distant as you walk next door. I've got on my muzzle, mask. So, hello, folks at home. Sorry for 2 breaks in 1 class, but we're all moving next door. That's going to take me a minute. I will pick up this laptop and walk with it. So that's going to be interesting. If you haven't seen the hallways lately, you'll see them now. So I'm going to pick them up, take them with me. All right. Let's see here.
By accidentally,
All right. Okay. Look at that. Let there be light. And there was light and it was good. All right. Okay.
Yeah.
Sorry for the inconvenience, everybody, but thanks for putting up with it.
Yeah, I couldn't get the thing pulled out.
Oh, okay. Well, better than it was before you got here. Thank you.
or whatever she taught last.
That's-
I don't know how to do this.
Oh, yeah.
I'm thinking. Every class I always think I'm gonna fail. Every class I think I'm gonna do, see if I can fail. Maybe not necessarily what you said, but other people's personalities.
15 hours of class.
I was like, oh no, here we go. Everything
Classes in the summer and live one extra each semester, so I have. It's not great.
Yeah, I know.
I was part-time before, I was doing full-time work and part-time school, and now I'm doing full-time school.
And I saw two, within my first year, I saw two new people, like, their last semester, they're stressing out, and they're full load. I'm like, I want the least amount of stress as possible for the last semester. So,
It's amazing time, well, 1 year, and now Corona and everything, so I'm not complaining, so. I'm getting done somehow. Instead of good bar.
I just started the legal services in Norfolk. I just started with last week, so. I think I'll get my hours done before. that starts. I'm very into doing research. I have to.
oh, wait, 12 left, okay.
Oh,
No, I cannot.
I'm a- I volunteered, like, my internship in the US comes up. I do my internship for the class, and then I just go on one extra week. You just do something. Josh, look like, you can use it for another week. Yes, you can still for another week. Right there.
No. No.
It's a PowerPoint presentation.
You broke it.
No, seriously?
There's a comment.
There's just one common denominator here, and unfortunately, he's standing in the front of the room with a ridiculous mask on his face.
I would say it's not that, I would say it's very.
Yeah, let's go with school.
So you propose we blame someone other than me. I'm with you on that. Yeah, I'm with you on that.
It's, if the IT guys are never here, so you can blame them because they can't realistically defend themselves.
Yeah. All right. Well, if I'm not mistaken, I think we've had just as much break as we've had class. So everyone has gotten up and moved to another room. Thank you. Thank you very much for accommodating that. It looked like the technology was going to work in here, but it didn't. So, hey, we'll roll with the punches, right? Can't keep a good man or woman down, right? Right? And I believe you wanted me to sing and dance anyway, right? Yeah. All right. So let's get back to chapter 3, shall we? Most importantly, let's keep a promise here, because I made y'all a promise, did I not? I promised that you weren't leaving this month without knowing how to file a grievance with the Florida Commission on Human Relations so that you could do something more than just lament the fact that someone you know, someone who's hired you, maybe someone you love, has become the victim of a constitutional law violation. I want you to be able to do more than just lament. I want you to be able to act. I want you to be able to litigate. So that's what we're going to do. But we left off in chapter 3. We just finished part A, and I could never spend too much time on Froggy versus Butts, but thanks to the technology, maybe I did. So let's move on to part B. Part B talks about pre-suit requirements, if I can find it. All right, here we are, part A, lawyer ethics, chapter 3, part B. Thank you, page 59. All right, prerequisites and pre-suit requirements. What am I talking about there? Well, as we mentioned, sometimes a constitution, be it the federal constitution or a state constitution, might speak in what you might call glittering generalities. It might state principles without actually giving you language that is actionable. What do I mean by that? For example, we have freedom of press. We have freedom of religion. But where's the cause of action? Where are the elements of the cause of action? They're not appearing in the text of the Constitution. This is true of our federal Constitution and some of its human rights. It is equally true of our state Constitution. Article 1, the Declaration of Rights of Florida's Constitution states such rights, but doesn't tell you how to do something about a violation. In order to have the right to do something about that violation, in order to have a cause of action, if you will, you need what's called an enabling statute. The enabling statute creates the elements of the cause of action. In so doing, the enabling statute might create a pre-suit requirement. This is certainly true when it comes to the Florida Civil Rights Act. We have a federal Civil Rights Act. Modeled after it, we have a Florida Civil Rights Act. But the Florida Civil Rights Act is a separate and distinct law. The Florida Civil Rights Act states within the Florida Civil Rights Act that it is to be interpreted consistently with federal law. But despite that statement, there are some differences between the federal and the state. One thing that is not a difference is that certain causes of action, such as employment discrimination, such as age discrimination, have a pre-suit requirement under the Florida Civil Rights Act, just as they do under the Federal Civil Rights Act. So what? Who cares what's in it for me? Well, allow me to illustrate. Imagine you are a practicing lawyer, which soon you shall be. You've got a client who feels the client's civil rights have been violated. Your client's been wronged. Matter of fact, that's your client's name, Ben. Ben wronged. So Ben wronged has been wronged. And imagine you're making this phone call. Hello, Ben. It's me, your lawyer. Oh, Ben, yes, I hear you. Oh, thank you, Ben, for the kind words. Yes, I know, Ben. I agree. I believe you were discriminated against. Yes, Ben. Of course I'm working hard on your case. I filed a lawsuit. I filed a complaint with the court as the very first step. And Ben, that's why I'm calling you. You see, Ben, I didn't learn in law school there was a pre-suit requirement. So even though you and I both know, Ben, that you were discriminated against, I'm sorry to tell you that, your lawsuit's been dismissed. And based on that dismissal, you're not the prevailing party. I know they discriminate against you, Ben, but now you owe them their taxable costs. You've got 30 days to write that check. Go ahead and send them that check, Ben. It's been great talking to you. Bye-bye. Do you want to make that phone call? No. Because what's the next phone call you make after that one? To your malpractice carrier, right? Another phone call you don't want to have to make. It's my version of a phone, by the way. That's what I was doing with my fingers there. It wasn't like hang 10 surfing. It was a telephone. Yeah. It's a good joke when you have to tell people what you're trying to get after, right? It's mark of a good joke. Anyway, my point is this. There can be pre-suit requirements. And when it comes to a violation of a state constitutional right that is covered by the Florida Civil Rights Act, there is a pre-suit requirement. And what is that pre-suit requirement? Well, just as the federal government has the EEOC, the Equal Employment Opportunity Commission, state governments have agencies like that. Here in Florida, we have the FCHR, Florida Commission on Human Relations, the FCHR. And the FCHR is the statewide agency. There are counties that have the equivalent of an FCHR on a county level. I believe Miami-Dade is probably one of them. You must exhaust these administrative remedies before you have the right to bring the lawsuit. If you fail to exhaust the administrative remedies, then your suit is dismissed. And you got to make that call to your client, been wronged, and explain that even though you and your client both know that there's been a violation, nevertheless, you lost and it's your fault. That's not a call you want to have to make. So question 1. Your client has been wronged. He works for a fictitious place, a department store, Bullseye, we'll call it. Any likeness to Bullseye to a real or existing department store is purely coincidental. So what's the first step you do for Ben? Do you rush out to the Supreme Court of the United States and file a petition for certiorari? Certainly not. Do you start at county court or circuit court, a state of Florida courthouse, and file a lawsuit complaint? Again, certainly not. First, you file a charge of discrimination. That's the technical name. And you file it where? You file it with either the EEOC, the Equal Employment Opportunity Commission, or the FCHR, the Florida Commission on Human Relations, or, here's a twist, dual file. That's right, you can file with one and ask them to have it dual filed with both. In my experience, that won't launch both agencies into parallel investigations. Instead, in my experience, based on work sharing agreements, one agency will be doing the work while the other technically has an open file but isn't doing much of anything, at least from my perspective. But you can dual file. What's your deadline? If you're filing with the EEOC, you have 365 days. If you're filing with the FCHR, you have 360 days. Oh, did I get that backward? FCHR, 365 days. EEOC, 360 days. Forgive me for misspeaking. What does that mean? That means that from the last act of discrimination, you have barely a year to file that charge of discrimination. Don't be confused by the fact that in Chapter 760, that's the chapter that contains the Florida Civil Rights Act, Chapter 760 has a statute of limitations that says the statute of limitations is 4 years. That is correct. The Florida Civil Rights Act statute of limitations is 4 years. But you can't avail yourself of court and therefore have that 4 years apply to you until you've exhausted your administrative remedy of filing with the FCHR. Now, McGinley, this sounds complex. McGinley, this sounds hard. How do I do this? You're going to need 2 things in order to be able to do this. First, a license to practice law, and second, a laptop. As I look around the room, most of you have one and are well on your way to the other. That's all it takes. Google the phrase Florida Commission on Human Relations. At the top of their page, it says file a complaint or ask for an investigation or words to that nature. Click on that and you fill out the form online and you hit send. Anybody can do that. You don't need 3 associates, 2 partners, 18 paralegals, a receptionist, and 2 floors on a high-rise building. You just need a license to practice law and a laptop, and you're at least halfway there. You have a question?
I'm gonna say for the 360 or 365 days.
Yeah.
I've seen the other part that says you have, they'll file within 180 days. If you wait until 360 or like 355 days, once you file, does that hold the time? Or because it takes up to 6 months afterwards?
Right. And you're asking about tolling. Of course, that's a complex question and it's a factual question. I can only give a general answer. The general answer is this. For going on the website, filling out that form and hitting enter, you've got 365 days. You might do it on day 365. That's okay. It's doing it on day 366 or later. That is not okay. Can you effectively argue that the 365 days were told? You might be able to meet that factual burden, but why put yourself in such a predicament? Just get it done. You meet with the client, you do it right then and there. Right. So if they met with you on day 366, you alert them that you haven't done anything wrong, but they may have missed their deadline already. Likewise, you've got that 4-year statute of limitations. So the agency is going to go into action. They have internal deadlines that they may or may not meet, but you're still responsible for getting the lawsuit complaint filed with the circuit court within the 4-year statute of limitations, regardless of what the agency is doing. The agency at some point is going to finish its investigation. It may issue you what's called a right to sue letter. That right to sue letter will state a deadline for acting upon it. Another outcome of the agency's investigation might be that they will find that there's no probable cause. That doesn't give you and your client the same rights that a right to sue letter would, because that is not an exhaustion of your administrative remedies. The right to sue letter gave you the right to sue, so you could go to circuit court and do what it takes to beat that 4-year statute of limitations, but the no probable cause finding does not. It gives you the right to ask for an administrative appeal. You have more work to do to exhaust your administrative remedies. So what you need to do there is get that notice of administrative review and appeal filed within that deadline. Of course, there are deadlines. In any area of the law, there are deadlines. Please don't be dissuaded from practicing this area of the law simply because there are deadlines. Regardless of what PC or phone you might be using, or Apple computer or Android device, there's a built-in calendar. You just calendar the deadlines. Or more effectively, what I've found more effective in my practice, I've been practicing since 1996, haven't missed a deadline yet. Maybe someday I will. So far, I haven't. I don't diary the real deadline, and I train my staff not to diary the real deadline. We diary a day or two in advance, and we pretend that's the real deadline. And then in addition to that diary, we diary a warning. Depending on what the task is, my staff is trained either 3 days, 5 days, 30 days in advance. So nothing ever results in one calendar entry. If there's a deadline, there's always at least 2 calendar entries. Likewise, I don't keep just one calendar. I know I'm old and I'm old-fashioned, but in addition to the digital calendar, I have a paper calendar. And whether you want to have paper and digital, or maybe just 2 versions of the digital, I encourage you to be redundant about it. Indeed, my software automatically syncs with the built-in calendar in Google. So in effect, I have 2 digital calendars and a paper calendar. Is that ridiculous? Well, I've never missed a deadline. You call it ridiculous if you want. It works for me. Find the system that works for you and meet it. And you can do it. You can do it. So this is how you do something about an alleged violation of a constitutional right. What is your burden of proof? What must you do? You're going to have to bring forth facts that prove up a prima facie case. You're going to have to show and prove that there has been a violation. You have to do more than just allege. How might you do that? There's 2 different ways, or categories of ways. One is direct proof, the other is indirect proof. You might refer to indirect proof as circumstantial evidence. Direct proof would do just that. It would directly prove the element. Indirect proof would allow you to make a reasonable inference of discrimination. Hey, the ghost in the machine, the tech is coming back. If you don't mind, I'll just ignore it since it's been ignoring us. So what's an example of direct proof? What's an example of indirect proof? Well, say you're representing Ben wronged. That's your client, Ben, and he's been wronged. And you gather proof. You have eyewitness testimony of Ben wronged supervisor, the one who fired Ben, screaming at the top of the supervisor's lungs, screaming, "It's his race. Fire Ben because of his race." That would be direct proof of discrimination, would it not? How often do you have such proof? Well, the case law describes direct proof as the rare case, as the unusual case. And in my experience, it truly is. I did have once a case of direct proof, once. So in my experience, the case law, calling it the rare case, is indeed accurate. What would be an example of indirect proof or circumstantial evidence? Well, Ben wronged worked for Bullseye, a hypothetical department store. Perhaps Bullseye is located in a neighborhood which is made up of citizens that are 80% population-wise the same race as Ben. Also exists in a neighborhood where statistics show that most people have a job within 3 miles of their home. But for some reason, only 2% of the population of the employees of Bullseye are Ben's race. So this fictitious department store is in a neighborhood that's 80% Ben's race, where most people work close to home. But for some reason, this department store population of employees is only made up of 2% of Ben's race. And to add more circumstantial evidence, after Ben was fired, someone of a different race replaced Ben in Ben's former position that Ben was fired from. Are all these things direct proof of discrimination? No, but taken together, they form circumstantial evidence. They form an instance of indirect proof. Obviously, you're going to need some discovery. Obviously, you're going to need some investigation to come up with such indirect proof. And that's the usual case, the indirect one. How are you going to get that done? Hey, think about it. What's that agency doing? That FCHR, that Florida Commission on Human Relations, that you just went on your laptop and typed and hit send. That's what they might be doing. Or they might not. But they might. So their investigation might help you with that. One of the outcomes of the agency is they might file the suit instead of issuing you a right to sue letter. They might do the investigation so well that they're confident enough to bring the suit instead of bringing the right to sue letter and issuing it to you. So that's the first step. That's the prima facie case. You're going to make that prima facie case through either direct proof, unusual, or indirect proof. Step 2, once you've met your burden as the plaintiff of the prima facie case, the burden shifts. That's unusual. Usually a plaintiff has and keeps the burden. Here, the burden shifts. It shifts temporarily. It shifts to the defendant. The defendant has this temporary burden to come forward with a non-discriminatory reason for that outcome. What's that? What's a non-discriminatory reason? Let me go back to our hypothetical. Remember Ben wronged your hypothetical client and he hypothetically worked at Bullseye? In the direct case, hypothetically, the supervisor who fired Ben yelled, "It's his race, fire him because of his race," right? Now that's prima facie case. It shifts the burden back to the defense. What would the defense have to do? They have to give us a non-discriminatory reason for that supervisor to have shouted that. Turns out, says the defense, the supervisor is a great fan of 5Ks, half marathons, and marathons. The supervisor happened to turn out was at such a 5K half marathon and saw Ben kind of not taking it seriously and not really running to the best of Ben's ability. And when the supervisor yelled, "It's his race, fire him because of his race," the supervisor was referring to that 5K, that half marathon, and how Ben just didn't give his best effort there. Now, what's that? That's two things. First of all, that's BS, right? That's not true, right? That's the first thing it is. The second thing it is that sufficient for the defense to meet its temporary burden and to shift the burden back to the plaintiff? What? That's all? That was cockamamie. That was BS. That was bunk. That was untrue. Yes, but now the burden's back to you as the plaintiff, and that's step 3. You now have to attack and disprove what the defense offered as a non-discriminatory reason. Step 3 is to disprove that. Now, in the direct case, obviously, won't be too hard. if you have the skills of what? Cross-examination. And very often, a discrimination case will turn on the lawyer's skills. Very often, it will turn on skills such as the ability to cross-examine. In this first hypothetical, where we have direct proof and the supervisor yelling, it's his race, firing because of his race, and then coming forth with the alleged non-discriminatory reason of, we're talking about running in a 5K or a half marathon, you're going to need an effective cross-examination. The jury has a factual question to decide, and you're going to cross-examine this individual. Well, how often do you go to 5Ks? How big a fan are you of running? Who else have you fired because you don't like the way they ran? Things of this nature. The same is true, however, for the instance of indirect proof. Remember, step one was to prove that prima facie case. You might do it through direct proof, or you might do it through indirect proof. The supervisor yelling it's his race, firing because of his race, was direct proof. My hypothetical example of indirect proof was statistics, right? Remember the statistics? We had a neighborhood that was, hypothetically speaking, 80 or 85% same race as Ben, but the employee population, unlike the neighborhood, was only 1% or 2% Ben's race. On step two, when the burden temporarily shifts to the defense, they're going to try to explain away those statistics, right? Well, we interviewed as many people as we could. We hired the very best person every time we interviewed and had no idea it would end up like this. We're just trying to get the best people. We always hired without any regard to race. I'm not sure how our employee population is different than the neighborhood population, but it's only because of our objective criteria and our well-trained interviewers. And then again, comes back to cross-examination, comes back to discovery, comes back to statistics. Take depositions, serve interrogatories, do requests for production, get the evidence you need to disprove that allegation. What I've just described to you, is this impossible for you? No. Need you graduate number one in your class from Yale or Harvard to put on such a case? Of course not. Any lawyer who passes a bar can do this. And perhaps every lawyer who passes a bar should be willing to do this, perhaps. Because to the extent that there is discrimination in this world, we lawyers are best equipped to do something about it. And I want you to be equipped to do something about it. And that's the point of this part of the lecture. I'm here to empower you. I'm here to teach you how to do something about it. And I hope this brief part of the lecture and the greater details you find in the book help to educate you as to this fact. Because when I opened this class, hour one of class one, I asked if you knew anybody who's a victim of injustice, or if you yourself were one. And there were no exceptions. Everybody either was or knew someone. And that's not good. That's got to change, right? And who's got the power to do that? The non-lawyer or the lawyer? Perhaps both, but who has the greater power, the greater opportunity? It's us. It's us lawyers. So let's step up to the plate. Let's get the job done. There are prerequisites, there are pre-suit requirements, but you can meet them. You can meet them, regardless of the type of case. Part C of our textbook talks about standing, right? What is standing? That's what you're doing when you're not sitting, right? Oh, boy. I warned you, there's very little humor in this class. Very little. Very little. Okay. All right. Standing. What are we talking about? We're standing. We're talking about the right, legal right, to be the plaintiff. The legal ability to be the one that brings the claim. Standing, generally speaking, involves an individual who has suffered actual and articulatable harm. Don't you hate the fact that the word articulatable is so hard to articulate? Mm-hmm. Articulable? Something like that. The harm that they could spell out and articulate. So standing is a question that is sometimes easy to answer and other times more difficult. If you're sitting on your front porch enjoying a lemonade and you're looking out and you see a stranger who's then run over by a car, can you sue the driver? Can you put down your lemonade and become the plaintiff? Probably not. Certainly not in Florida. barring some sort of unforeseen thing like that was your spouse out there and now you have a loss of consortium claim, generally you need direct harm. That fact begs this question. Why is it sometimes that groups can bring claims? And that's what we're addressing in our standing section. And with the case of Alachua County versus Sharps, this is a case from the First District Court of Appeal of Florida. And it talks about an interesting question of standing, and in so doing, spells out much of Florida's standing law. What we had here was a county. This county, Alachua County, back then, sometime before 2003, because it's a 2003 case, wanted to spend taxpayer dollars to put on the ballot the following non-binding referendum. Vote yes or no. Do you favor legislation to create a system of universal health care in Florida? Asks Alachua County. Universal health care in Florida, asks Alachua County. Can Alachua County, I know we haven't covered municipalities and municipal law yet, but take your best guess here. Can Alachua County dictate to the entire state that the entire state must offer universal health care throughout the state? Does Alachua County have that power? What's your best guess? Everybody's shaking their head no. You have guessed correct. Ding, 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 ding. You will find when we study the powers of counties, they do have lawmaking powers, but not extraterritorial lawmaking powers. Alachua County can't pass a law that applies in Miami-Dade County, that applies in Duval County, that applies in Orange County. Alachua County can pass laws that apply in Alachua County. Sometimes, not always, but certainly not an extraterritorial law. So this individual doesn't want his taxpayer dollars wasted on this referendum. They truly were a waste, right? But the question is, does this individual have standing? So we go through the law there. First, we talk about taxpayer standing. And if taxpayer standing exists, then almost all of us can sue any government we pay taxes to, right? If that's all it takes, I'm a taxpayer and therefore I have standing. That would be a very broad interpretation of standing. That's not the federal standard. And as we learn in Alachua County versus Sharps, that's not the state of Florida standard either. The mere fact that you pay taxes to that entity, that alone does not, NOT, does not give you standing to sue that entity. That's the general rule. Equal protection standing is addressed next. Appellee's equal protection argument, goes the quote, is premised on the argument that because the board's discretion to pick and choose among petitions for referenda has not been circumscribed by adequate guidelines, general equitable protection principles would render it unconstitutional in application. Goes on to explain, however, because the plaintiff did not attempt to get an alternative petition placed on the ballot or offer his own ballot for submission, he cannot show that he suffered any discrimination. It is not enough that others may be discriminated or that others may be discriminated in the future. So he lacked that direct, articulable, and personal harm to bring the claim. Equal protection standing was not sufficient. Notes and questions to consider. Note 1. In Alachua County versus Sharp, the court notes that the rules regarding standing are relaxed in cases of statutes and rules that on their face allegedly violate the fundamental right of free speech and expression. Interesting. So we have a different standard of standing if we're talking about freedom of speech and freedom of expression. The concern is that the legislation may have a chilling effect. What's that mean? What's a chilling effect? What we're referring to there is that the legislation may prevent the speech from ever happening. It will chill the effect. It will cool the speaker. It will prevent the speaker from ever speaking. Therefore, we won't have a speaker with that direct and articulable harm. We value freedom of speech so much that we make an exception for standing under freedom of speech in order to avoid the chilling effect. If you'd like more details about that, I encourage you to finish reading Note 1 under Notes and Questions to Consider. Note 2, sometimes in a lawsuit alleging a violation of Florida's Constitution, the plaintiff is not an individual. Interesting. Surely we have all seen news reports of groups such as the Becket Fund for Religious Liberty and the American Civil Liberties Union bringing lawsuits challenging the constitutionality of a law, regulation, or government action. Some organizations appear to make such litigation one of their primary purposes. And then the question is, what gives them standing? So whether it's the Becket Fund for Religious Liberty, whether it's the American Civil Liberties Union, whether it's a trade union, whether it's a club or a group, what gives the group standing? The general answer is this. Generally speaking, if it can be shown that the members have that direct, articulable, and personal harm inflicted upon them, and that's generally true of the membership, then the group, on behalf of its members, has the same standing. That's generally speaking and generally the rule. For more details, I give you a site there. So if that particularly interests you, go ahead and pull Fraternal Order of Police, Miami Lodge 20 versus City of Miami. And indeed, you don't have to pull it. I got it right there in the book. You can read it yourself. That'll give you more details. Part D of our discussion of litigating constitutional issues talks about indispensable parties. What's an indispensable party? Well, the standard of law is the same as the definition of the word indispensable, if you think about it. Indispensable means something that can't be done without. If you can't be done without that party, then that party is indispensable. Another definition would be, if it's necessary for that party to be before the court in order for the court to grant relief, then that party is an indispensable party to the court and to that lawsuit. A lawsuit must involve the correct participants. The Florida Rules of Civil Procedure allow a party to move to dismiss an action for failure to join an indispensable party. An indispensable party is one whose interest in the subject matter of the action is such that if he or she is not joined to the suit, a complete and efficient determination of the equities, rights, and liabilities of the other party is no longer possible. So that's your legal standard. Florida Department of Education versus Glasser is in the book. Really short version of it is in the book because it was a setup. It was a setup. It was a sham. The school board filed its action for declaratory judgment against the tax collector without naming as a party the Department of Education or any other state agency. The board and the tax collector, again, without the Department of Education or any other state agency, got together and stipulated to an expedited hearing to be held the very next day after the suit was filed. At the same time, they notified the Attorney General by sending him a fax. What was going on here? They got together in advance and wanted a particular outcome. They thought they'd pull a fast one, right? But not joining the indispensable parties. But the court can't go forward. Can't do that. That's the takeaway, Florida Department of Education versus Glasser. That's Part D, indispensable parties. Let's look at Part E. E talks about give notice to Florida's Attorney General who may intervene. What is an Attorney General? Well, under the federal Constitution, that has a different answer than the answer under Florida's Constitution. Under Florida's Constitution, the Attorney General is elected by the people. It is a cabinet level election. The people directly elect Florida's Attorney General, In the federal system, the president, as the chief executive of the federal government, nominates cabinet members who then have that job with the advice and consent of the Senate, which for practical purposes means the nominees go before not the full Congress, they skip the House, they just go to the Senate, and the Senate votes yes or no to confirm the nominee. That's the federal system. It's in the federal Constitution, which I know y'all told me already. You didn't read that in Federal Con Law 1. But please read our state constitution, because I'm going to keep referring to the text of it here in Con Law 2. Here, although this is a cabinet level position, the governor, who's the state's chief executive, does not nominate or appoint the attorney general. The attorney general runs and gets voted on, or the attorney general's opponent might get more votes. Under the federal system, you'd never probably have a situation where the president and the attorney general are of different parties or of different mindset, because the president's going to pick probably someone from the president's own party, and most likely someone with the president's own mindset, someone who agrees with the president's agenda, someone who wants to advance the president's goals or shares the president's goals. Here in Florida, the governor and the attorney general might be opposite parties. The people might elect a governor of one party and a election of a Florida attorney general of another party. They might be opposite parties. They might have opposite goals. They might have opposite agendas. We literally have a governor with a cabinet that could be a cabinet of enemies. That's possible here. What's Florida's Attorney General's job? When we look at the executive branch in our chapter later, and we look at all the cabinet members, we'll give you more details on that. For now, let's focus on just one of those jobs. The Florida Attorney General has the job of defending Florida statutes. That's one of Florida Attorney General's jobs. Compare and contrast that to the federal Attorney General. I don't want to cross the line from political science into politics, but perhaps you can think of a fairly recent example where the federal Attorney General has decided that law is unconstitutional. I'm neither going to defend it nor enforce it. That is a possible outcome under the federal. Not so under Florida's Constitution. Florida Attorney General has a constitutional and statutory duty to defend the constitutionality of a duly enacted Florida statute. What if the Attorney General of Florida doesn't like that statute? What if the Attorney General of Florida, if they had been the lawmaker, would never have made that law? Still, Florida's Attorney General has a constitutional duty and a statutory duty to defend, to uphold, to fight for, and to enforce that law, even if the Attorney General wouldn't have written that law that way if the Attorney General were the lawmaker under Florida's Constitution. But the Attorney General is not the lawmaker under Florida's Constitution. What's the relevance of that? For you as the litigator, you've got to give notice to Florida's Attorney General whenever you challenge the constitutionality of a Florida statute. Do you want to do that? Will Florida's Attorney General rush to your aid in trying to argue that Florida statute is unconstitutional? No. Not if the Florida Attorney General is true to and obedient to Florida Attorney General's obligation under the Florida Constitution and the Florida statutes. So you might not want to do it, but you have to do it. And if you fail to do it, either the court on its own motion or your opposing counsel can stay the litigation until you do it. So for that reason, and for the reason we discussed earlier about indispensable parties, there'll always be an adversary to your lawsuit if you're trying to argue in a Florida state court that a Florida statute is unconstitutional, right? But that's true of any drama. Any great drama is going to have a bad guy, right? I don't know what drama you enjoy. For me, one of my guilty pleasures is Star Wars. Maybe you're familiar. Can you imagine Star Wars and Luke Skywalker without Darth Vader? Nah, it wouldn't be the same story, right? Or if you like the newer version of Star Wars, can you imagine Rey without Kylo Ren? I know they kind of came together and, spoiler alert, one kind of brought the other back to life or something like that in the last movie. I don't know what happened there. But my point is this. Every great drama has an adversary. Your Florida constitutional law litigation will have an adversary because you have to join indispensable parties and you have to give notice to Florida's Attorney General. Must Florida's Attorney General intervene? No. That's where the Attorney General has discretion. If Florida's Attorney General intervenes, then we know what side Florida's Attorney General is on, because the Constitution of the state of Florida and the Florida statutes say that the Attorney General must be on the side of the statute, must argue that the statute is constitutional, must fight against the plaintiff who's arguing unconstitutional. But the Attorney General does have discretion to not intervene and simply not join the suit. So that's where discretion lies under Florida's Constitution. Let's talk about Section F, remedies. I need a remedy for what is ailing me. And what's ailing you is an alleged constitutional law violation. What remedies are there? What can you do for your client? And the remedy might mean everything to your client, right? Perhaps your client just wants to make sure that no one else has to suffer the way your client suffered. Such a remedy for such a client might be sufficient, such as an injunction. What is an injunction? It's an order from a court directed against another that says, don't do that. Stop doing that. Always do this. These are examples of injunctions. Is injunctive relief a potential remedy for a given Florida constitutional right violation? Most likely, yes. What if your client, in addition to not wanting others to suffer the way your client did, would also like to pay the bills, put food on the table for themselves and their loved ones, put clothes on the backs of their dependents and children? Maybe they also want the money. Can you do that in Florida? Can you get money as a remedy for a constitutional law violation? In most instances, yes, that will be an available remedy. Under Florida, another available remedy is called a declaratory judgment, or what the practitioners will sometimes abbreviate as a DEC action, DEC, short for declaratory action or declaratory judgment. What is that? It's somewhat like an injunction, but what it is, it's a question to be answered by the court as to what are my rights? What are my rights? It's a statutory cause of action, has 6 distinct elements that are spelled out for you in the book. The gist of which is it can't be a merely academic question. It can't be something that is removed from reality insofar as you're not determining the actual rights, responsibilities, and liabilities of an actual person, an actual plaintiff in an actual factual situation. So it can't be that, well, I'm just curious as to whether or not this was constitutional to do that. Instead, you're looking for something along the lines of, I've been elected as Florida's Attorney General, and I'm wondering what my duties and obligations are. Because it's a statutory cause of action, it goes beyond constitutional actions. You might be a private party who's entered into a contract and you're not sure what your obligations are under the contract. You can file a DEC action. You can file an action for declaratory judgment, find out what your obligations are under the statute. So it's a powerful cause of action that goes beyond just constitutional law questions. But there has to be an actual case or controversy. Here's the 6 elements. It's got to be a bona fide, actual, present, practical need for the declaration. That's element 1. Element 2, the declaration has to deal with the present, ascertained, or ascertainable state of facts, or present controversy as to the state of facts. Element 3 of 6, some immunity, power, privilege, or right of the complaining party is dependent upon the facts or the law applicable to the facts, element 4 of 6. There is some person or persons who have or reasonably may have an actual present adverse and antagonistic interest in the subject matter. So you got to have a bad guy. Luke Skywalker needs his Darth Vader. Element 5, the antagonistic and adverse interest are all before the court by proper process or class representation. And element 6 of 6, the relief sought is not merely giving of legal advice by the court or the answer to questions propounded from curiosity. So that is a long-winded way and a far more technically correct way of stating the elements of a cause of action that seeks to spell out rights, duties, and responsibilities without giving advisory opinions, without answering hypotheticals, without violating the case or controversy requirement. So that was element F, or part F of chapter 3. Part G of chapter 3 talks about fee shifting statutes and awards of attorney fees. I'm seeing people falling asleep here. Come on now, stay awake. Here, I'll help you stay awake. I'll ask you an invigorating question. Answer this question for me. Answer this question. There is nothing so precious, so cherished as our constitutional rights, correct? Constitutional rights of us and our fellow citizens, correct? But yet there are individuals who live month to month, who live hand to mouth, who have more month than money, whose budget runs out, who can't afford a lawyer, who don't have money for legal fees. But their constitutional rights have been violated. So certainly that means that they have a right to an attorney. Isn't that right? Is that right? Tell me, is that right? If I have suffered a constitutional law violation, that means I have a right to counsel? Is that right? Answer is no. My constitutional rights have been violated, but I don't have enough bank to pay for a lawyer. Does that mean the government opens its wallet and pays for my lawyer? No, not necessarily. Not necessarily. Despite the fact that our constitutional rights are so cherished, so important to us as a nation, as a state, still the American rule applies when it comes to attorney fees. And you've studied that in other classes. The American rule is that each side pays its own lawyer, right? Unless there's a statutory or other textual law basis for shifting attorney fees. And that statute or textual basis is strictly construed, not liberally construed. Strictly construed, all the elements must be met. And that's true even in constitutional law violations. So Part G talks about fee shifting statutes and awards of attorney fees. You have to find such a statute. It's not a default. It's not a given that there is such a statute. That's point number one. Point number two is you've got to meet all the elements. You bear the burden of proof if you're the one attempting to recover attorney fees. That's point number two. Point number three is your attorney fees are reimbursed. They're paid after the fact. So if you're the potential plaintiff, if you're the victim, either you're paying out of pocket in hopes of recovering that money later in a separate action where you bear the burden of proof and you may or may not meet that burden of proof. Even if you win the underlying cause of action, you might fail to prove attorney fee entitlement. Those are separate and distinct questions. Or you've got to find a lawyer, if you're the potential plaintiff, who's willing to work on a contingency and join you in taking that risk of perhaps not getting paid, even if there's victory on the merits. There still might be a loss on the attorney fee entitlement claim, despite the victory in the merits. There are individuals who have a claim, but there's some bad facts in there, or there's an unclear law in there, or there's a question of proof in there. And they simply can't find a lawyer who's willing to take the risk and take in that case on a contingency. That happens. That happens. Let's take a specific look at one particular attorney fee shifting statute. Let's look at, generally speaking, actions under Florida Statutes Chapter 760, which is that Florida Civil Rights Act that we talked about earlier. You remember when we talked about the Florida Civil Rights Act and we talked about the agency created under it. We talked about that Florida Commission on Human Relations, or FCHR, and how it was part of the pre-suit requirements of the Florida Civil Rights Act under Chapter 760. Let's talk about that same act and the potential for attorney fees. There, like most attorney fee statutes, you bear a separate burden of proof. And that burden of proof is different for both attorney fees versus costs. We're going to talk about fees and we're going to talk about costs. Do you know the difference? If you're a practicing lawyer, you do. If you're not, let me tell you now. Fees talks about labor, talks about compensation for the attorney and the paralegals, legal fees, and legal work. Costs talk about money out of pocket, generally paid to third parties, but under the statewide uniform guidelines for taxations of costs in Florida, sometimes it's money out of pocket from the lawyer. Sometimes there's even a potential for a certain amount of overhead to potentially be in part included somewhat within those costs. So labor versus non-labor might be a general way of looking at it. Hours versus dollars might be another general way of looking at it. But no matter how you look at it, you have to understand the difference between fees and costs. Costs under this Florida Civil Rights Act and the Florida Rules of Civil Procedure will be awarded to the prevailing party. If there is one. Somebody's got to win, right? And it's a different inquiry for fees and for costs as to whether or not there's a prevailing party. Remember when I tried to make my hand look like a phone and you were telling Ben wrong that he got dismissed and therefore they were the prevailing party and he had to pay costs? Remember that little hypothetical joke, which wasn't so funny because you could picture yourself in that situation? There, if the outcome is clearly in one party's favor and not the other, and the litigation is final and there's nothing further pending, you know who the prevailing party is when it comes to costs. When it comes to fees, it can be a different matter. The court has to weigh what was at issue in the lawsuit and whether there was a prevailing party based on the particular factual issues involved in that particular suit. It could be that there's not a prevailing party for attorney fees under the Florida Civil Rights Act under Chapter 760. Let me see if I can give you a hypothetical example. Ben wronged, exhausted the pre-suit requirements, brought the suit against Bullseye, and won. After 2.5 years of litigation and experts proving up what 2.5 years of lost wages and employment benefits looked like, and had that $1.2 million claim up on the chalkboard ready for the jury to award, the jury said, yes, we find discrimination, and we award $1. Now we have a factual question for the judge to answer. What were the issues in the suit, and was there a prevailing party? See how the answer could go? Either that Ben, although he proved discrimination, maybe either wasn't the prevailing party or neither party was prevailing. See how that might be the outcome? More importantly, if you're on the defense on that side, can you imagine how you might argue that the outcome is that neither party is a prevailing party? And you see arguments like that. And before we leave the Florida Civil Rights Act, Chapter 760, and its fee shifting statute, we would be remiss if we did not point out that it is a one-way street. a slang term, of course, but what I mean by that is that one side has a different standard than the other. If you are the plaintiff, if you are the aggrieved, if you are the party who alleges the civil rights violation, then you get your attorney fees if you prevail. But it's a one-way street. So under Chapter 760, the Florida Civil Rights Act, it's not true that if the defense prevails, it gets its attorney fees. Listen to my words carefully. I'm talking about attorney fees. I'm not talking about costs. Remember how those were two different things? Focus now on attorney fees. It's a one-way street. All the plaintiff need prove under Chapter 760 is that it was the prevailing party. That is not sufficient for the defense's burden of proof. The defense must prove more, and probably can't, because the defense will have to prove that it was a frivolous claim. And that brings us full circle to the beginning of our lecture. Remember, we talked about how low it had to sink before it was frivolous, right? Just because you lost doesn't mean your claim was frivolous. Remember that discussion? So the defense has a higher burden. So it's a one-way street because the standard is not the same. That's Chapter 3, Part H. Ooh, Part I. Can anyone even pronounce this? Is it amicus? Is it amicus? Is it amicus curiae? Is it amicus curiae? I don't speak Latin. Wish I did. I should take the time. First, I should probably take time to learn Spanish. Always wanted to know Spanish. Studied French in high school. Know a little bit of it. I'd like to know more French. That's a long list. I want to know Spanish, French, Latin. I digress. Amicus, amicus, say it as you will. But what does it mean? What are we talking about? I guess loosely translated, again, I don't speak Latin, something like friend of the court. An amicus brief is a brief from a party in that appeal that's not a party. Talking on both sides of my mouth there. You've got the party, right? You've got the plaintiff versus defendant. And then you've got the appeal where one of those, the winner, is going to be called appellee. All the winners get that title. And whoever files the appeal or joins in the filing becomes appellant. So you've got appellant and appellee. Those were the parties below, and now they're the parties to the appeal. But maybe somebody else wants to jump into that case, put their 2 cents in. These things happen. Happen to me. Could happen to you. Attorney calls me up. His organization wants to join in as amicus. Do I have any objection? Sometimes, maybe it's a private party. Maybe it's a trade union. Maybe it's a lobbying group. Maybe it's a trade organization. Maybe it's a club. Who knows what it is? But we all know that appellate decisions become law, right? They become case law. They become binding case law precedent. They affect the rights of non-parties. So sometimes those non-parties want to be heard. And that's what amicus are. They are non-parties who not only want to be heard, but do something about it and get to talk in that litigation. So there are some restrictions there. And that's where I've got the Saibagigi versus the fish peddler in there. Again, the merits of that case was not why I included it in the book. It is the procedural question of the amicus is why I put it in there. So what is it that the amicus can do and can't do? And there are restrictions. The amicus, if permitted by the court, can file their own brief, taking their own position as to the issues before the court. Can the amicus expand the litigation and add some other issues? No, that's not within the right of the amicus. Saibagigi versus the fish peddler says, well, whichever side of the argument you're on, amicus, you should kind of team up with that side and kind of get together and kumbaya, all holding hands and getting along and being great friends and maybe split up the argument, try not to repeat one another. And you could see from a judicial standpoint how a judge might like that, right? But you could also see from a logistics standpoint how maybe it wouldn't be all kumbaya and come together and friends. In my particular instance, when I got that phone call from this attorney asking if I had any objection to the motion to appear amicus. I said, yeah, I do object. Well, why? You know, we're on your side. We want the same outcome. We're arguing for you to win. But in my mind, I've got the winning argument. I've got the right presentation. This other party's going to butt in. They're going to mess up my presentation. They're going to focus on a different argument, perhaps. I don't know. Remember, we began this lecture with Jones versus Barnes, the case I lovingly call Froggy versus Butts, right? And there, an attorney has the discretion, has the power, has the freedom to advance this winning argument, but not that winning argument, to emphasize this argument and de-emphasize that argument. If amicus jumps in, they've got the same discretion. I'm losing control over my case. I'm worried about winning my case. I'm worried about being persuasive. So that's one thing to consider when you decide whether you want to object or not object to amicus. There's other notes and questions to consider. Quote 1. In the opinion above, Saibagigi versus Fish Peddler, the court made the statement that amicus briefs are generally for the purpose of assisting the court in cases which are of general public interest or aiding in the presentation of difficult issues. Do you agree with this statement? At least one commentator does not. And I got the commentator's words in there. This is former Judge Philip Padovano, writes Florida Appellate Practice, one of the books in the West Florida Practice series, which are a bunch of great books. You should buy them all, including the 4 that I write for that series. But anyway, I digress. Judge Padovano wrote this. This statement is one that was made by an appellate court and it necessarily reflects a judicial perspective. An advocate may have other good reasons for filing an amicus brief. The association or individual submitting the brief typically has some interest in the precedent that will be set by the court's decision. Appearing in the case as amicus helps to ensure that a particular argument can be made before a decision is made. Amicus briefs are usually filed to support the position of a party, but that is not always the case, right? Once they've got party status, what if they turn on you, right? It would be proper to submit an amicus brief that addresses the issues without supporting the view taken by either party. Ooh, I got some like neutral third party button in your litigation. You can see some of the issues that might arise there. Question 2, and I'd love to hear some voice other than mine. I'd love to hear your answer to this question. In your opinion, and any question that starts like that has no wrong answer, right? So please don't hesitate to chime in. In your opinion, should appellate courts be more willing or more reluctant to allow amicus briefs in cases where the parties raise issues under Florida's Constitution? So if it's a case involving a constitutional issue involving Florida's Constitution, in your opinion, there's no right or wrong answer here. Should courts be more willing or less willing to hear from amicus? Yes.
I'll say yes, power in numbers.
So you say they should be more willing.
More willing.
Why do you say that?
It's power in numbers. You're going to be before usually a panel of judges. Each of them have their own opinions. If you overwhelm them with the number of good arguments from multiple people on your side of the table, you might overpower any responses, rebuttals, prepared statements that they have.
I think I see what you're saying. So you're talking about strength in numbers.
Mm-hmm.
Strength in numbers. Leader of the pack. Let them hear the voices. I like that. I like this. 3 other hands. Yours was first, Mike.
I'll argue the opposite. I think that a stronger argument is a normalized argument. So
I like that.
Talk about kind of like wording down your points,
Mm-hmm.
and usually a judge will, you were saying like appellate review, they're inclined to believe, something is unconstitutional. So the more that you add on it, I don't know. I'll use a sports analogy. If you have 2 quarterbacks, you don't have one. So,
Yeah.
the more arguments you have, the least likely it's to be strong.
Yeah. So you heard Mike, he's disagreeing with your strength in numbers argument. How do you rebut Mike's comment?
I don't. It's a valid. I mean, we both have valid. It doesn't.
Yeah.
I'm not sitting judge, so.
No, I agree. You both have valid points. Yeah. Yeah, there's 2 more hands, but yours was first, and I won't forget you. Yes.
Strengthen numbers, but also by allowing the amicus briefs or the
Mm-hmm.
amicus additions, that would help minimize further litigation of the same issue. By condensing it to that one trial or that one hearing.
So I guess to paraphrase what you're saying, and you didn't use these words, so correct me if I'm wrong, you see some sort of judicial economy going on here, like well use of judicial resources well used. Is that kind of along the lines of the point you're making? Okay, all right. And would either one of you disagree with that? There was a fourth hand. I didn't forget you.
Okay, so for me, I'm looking, by strength of numbers, you also are like stating that who has the more money that can pay for all these bigger numbers, their voice, just because of they have the money to pay for and facilitate the legal fight.
Yeah. It costs money to be an amicus.
That they're
Yeah.
going to be, their voices are going to be heard more versus if you're a poor litigant and you only have the ability to pay for one lawyer and
Yeah.
his team or her team,
Yeah.
and that's it. So by your statement, you can have all these other people just because they have money and they may agree with it, but they might not necessarily make right. But if you have that many people,
And might shouldn't make right, especially when we're talking about a court of law, right?
and
So I
if
see
you-
your point. It's, not everyone has access to an attorney, let alone the ability to jump into cases where they're not directly impacted on the particular case and controversy to the point that they would have a judgment either for or against them out of that particular case. But yet amicus and the law of amicus curiae allows such individuals to enter a case. But look at the financial constraint, I think is what you're saying.
Right. I'm
This,
saying for-
these are dollars. The ordinary Joe on the street doesn't have extra dollars in his monthly budget to hire an amicus.
It may not be popular for the victim that's trying to appeal.
Yeah,
It may be popular for the people that are financing the other side, and if they just love the court with all these other things that they can afford because it's popular for them, and the outcome will come for them financially, the returns will come back to them.
Yeah.
Whereas the other person that's poor, they don't have and it may not be as popular or even as well known of an issue, but just by the sheer numbers, they get over flooded and their voice gets squashed.
yeah, that can happen. A new hand went up and the Mike wanted to chime in again. I won't forget you, Mike. Yes. Yeah,
So litigants have to pay for lawyers.
that's right. The American rule applies and litigants are paying for their own lawyers. And I gave you that dramatic way of asking the question and saying how there's nothing more cherished than our constitutional rights. So then shouldn't there be a free lawyer? The criminally accused might have a public defender, but when Ben wronged is allegedly suffers a civil rights discrimination by being fired by Bullseye, his employer, there isn't a public defender. There's not a public defender who offers free legal services to bring the lawsuit for Ben. One might argue that the pre-suit requirement, the Florida Commission on Human Relations, the FCHR, is akin to such a right, but obviously it's different. You're in front of an administrative agency. You're not in front of a court. The agency is doing an investigation. They're not necessarily on your side. They're certainly not your advocate. They're certainly not your lawyer. So yeah, the American rule applies, and you got to open your wallet if you think you've had your civil rights violated. In most cases, like we talked about, you might try to find a contingency lawyer, or you might not succeed in finding a contingency lawyer. But yes, does that clarify where the attorney fees come in?
That includes like the amicus.
Oh, that includes the amicus too. Yeah, if someone wants to be an amicus, they're either a lawyer themselves and they're donating their time, or they're working for an organization and the organization is paying them to do this. Or I don't know, I guess you could work pro bono for such an organization, but somebody's either paying or working for free. The government isn't opening the government's coffers and paying private litigants in civil rights cases for the most part, unless there's a fee shifting statute and there's a prevailing party who, after prevailing, brings a separate action where the party bears the burden of proof and succeeds in meeting the strictly construed requirements of the fee shifting statute. So it's a mouthful, but since it's a mouthful, it helps to illustrate how difficult a burden that is. Does that help with the understanding? Does that help clarify? Okay, thank you. But Mike, you wanted to chime back in. You had your hand back up.
Push back just a little bit. on-
Yeah, push back. Let's get some debate here.
This is the initial argument, and I'm just speaking from the perspective of being a law student
Yeah.
Having a job, having an internship, and being required to maintain a certain level of excellence as a student.
Yeah.
With these Supreme Court justices, they should be the best as far as our courts are concerned. And so if we can't expect them to be able to rightly divide the law as they should, why are they Supreme Court justices? They should be able to do their job at the highest level, whether or not they have 100 briefs or whether they have one. They should be able to take the Constitution, divide it. Also, for the fact that the states is opening up its coffers and paying the judges.
That's true. Somebody turned on the lights in that courthouse. Somebody has staff at that courthouse, and it's our taxpayer dollars. It's paying for those lights and paying for that staff. It's true. And that brings us back to earlier points, both at the beginning of this chapter 3 and the beginning of chapter 2. You know, judges have an obligation, and it depends on your point of view. In my point of view, a judge should be justice is blind. A judge should be an impartial decider. A judge should be the umpire calling balls and strikes. In my opinion, the judge shouldn't be politically motivated. In my opinion, the judge shouldn't be trying to make law or trying to give us law from the bench. A judge should be simply determining what the truth is based upon a fair interpretation of the evidence, and then blindly applying that fact-finding truth to the true meaning of the law, and having that lead the judge to wherever it leads, regardless of what the judge's personal opinions are, regardless of what the judge's personal beliefs are. You know, we all have our own personal heroes. You know, the dogma sounds loudly in Amy Coney Barrett. Got a t-shirt that says that. And I don't know about you, but I watched with joy her confirmation hearings, because she and I share a faith. And as strong a believer as she is in Christianity and as strong Catholic as she is, I not only respect that, but I respect the fact that she was vehement about the fact that she puts her faith and her beliefs as a personal nature and puts them aside and separates that from her duty to call balls and strikes, to hear the facts, and to apply those facts to a fair and impartial interpretation of the law, and to follow that result of fair facts and impartial law to wherever it may lead, whether or not that's where she wanted it to lead. She wasn't leading it in a particular direction. She let the law and the facts determine the outcome. She wasn't about a political agenda or a religious agenda. And I had so much respect for that, so much respect. And maybe you do too. I hope you do too. But Mike, I guess your point was these are taxpayer dollars and these judges have to do a job. And I agree. Did I miss a hand? All right. Well, it's just about quitting time. I know we had a lot of technical problems today. Maybe the computer works, maybe it doesn't. I have no idea. But y'all jumped up and changed rooms, turned a 10-minute break into a 25-minute break. We had lots of obstacles today, and you stuck with me. We overcame them. And did you notice the lights in the back row keep going on and off? What's with that? Am I to blame for any of this? I feel I am not to blame for any of this. But anyway, you're not to blame for it either. But yet you put up with it, and you got through it. And you put up with me, and I appreciate that. Hope I've answered all your questions. We've now finished chapter 3. And I hope that I'm keeping my promises. I hope I've empowered you to do something about a civil rights violation. Our 4th class comes next week. We're going to talk about chapter 4. And until then, may God continue to bless us all. Thank you and good night. I like this room too. Yeah, I'll take this room next time. But if they would please add a working computer, I would appreciate that. I'm not sure who to talk to. I'm going to find out and I'm going to talk to him. Yeah, I'm going to talk to him.